And my lord, at paragraph 23 of that decision, the other paragraph was paragraph 17C in its entirety. Well, the next decision I wish to refer you to is HCC 165 of 2022, Philomena Mbete Mwilu versus the British Broadcasting Corporation. Again, my lord, here your sister, Lady Justice Janet Mulwa, was considering the proof by way of, or the alleged proof by way of electronic service. And the electronic service, again, was by way of Order 5, Rule 22B. And at paragraph 22, this is what your learned sister states. Despite the plaintiff's submission that it indeed effected service via email addresses of the defendant, it failed to prove such service by filing an affidavit of service of the process server, and I emphasize attaching the electronic mail delivery receipt to confirm such service. My lord, that is what the law recognizes as proof of service. You don't print out the email you sent, attach it to an affidavit, and say you seek to persuade the court that you served as the law requires. My lord, later on in paragraph 23, in the second part of paragraph 23, to that extent, therefore, the plaintiff having failed to tender proof of service of the summons and the pleadings by email to the defendant, in terms of Order 5, Rule 22B, Sub-Rule 2, the court finds that the alleged email service on that date upon the defendant to have been defective in the first place, even if it was effected. And I wish to emphasize the next paragraph, the next sentence. The importance of service cannot be overstated. It accords the sued party an opportunity to be heard before any orders are issued against it, and this is a tenet of natural justice, which all legal systems allude and abide by, and it was held by the Court of Appeal in Patrick Omondi Opio trading as Dallas Pub versus Shaban Keller. My lord, that brings me to an important point. Service is an important gateway to the right to a fair hearing in Article 50. And my lord, I'm sure you have heard the provisions of Article 50 bandied about many times. But I wish to state that, my lord, the obligation or the duty that Article 50 vests is in the court. The duty vests the court with the duty, my lord, to ensure. And Article 50, the relevant parts of Article 51 is worded as follows. Every person has the right to have any dispute that can be resolved by the application of law. It is the court that resolves disputes, and it is the dispute resolver that duty is placed on. My lord, service is such an important part of court processes that Order 5 of the Civil Procedure Rules then reserves service to officers authorized by the court. Not anybody can effect service. Only those authorized by the court are able to effect service because of the importance that service plays in the attainment of that right. My lord, the last decision I wish to refer you to is the decision of the Court of Appeal in Patrick Omondi Opio trading as Dallas Pub. It is the one referred to in the last decision. Patrick Omondi Opio trading as Dallas Pub versus Shaban Care. Patrick Omondi Opio trading as Dallas Pub versus Shaban Care and another, civil appeal number 68 of...
Already referred to the other matter?
Yes, it is already referred to in the earlier matter. But my lord, I wish to refer to a specific holding of the decision of the Court of Appeal in this matter. And at paragraph 19, the learned judges of the Court of Appeal held as follows. Service of summons accords the sued party an opportunity to be heard before any orders are issued against him or her. That is the essence of the rules of natural justice, which all legal systems uphold. Applaud. Paragraph 19. My lord, the Court of Appeal confirmed in this holding that that is the purpose of service. Of our Constitution. Are we together, my lord?
Yeah, I do know.
All right. My lord, the Court of Appeal then goes on to say, where therefore judgment is entered against a party who has not been served and hence not been heard, such judgment will be set aside ex debito justitia. Ex debito justitia, my lord, loosely translated, means as a debt to justice.
Yes.
My lord, I have been at pains to persuade you this morning in paragraph 11 of both the supporting affidavits the applicant's last confirmed and used email addresses are set out.
Well,
In paragraph 11 of the affidavits in support of the application.
last used where?
I beg your pardon?
Last used where?
Last used by themselves.
Where?
I beg your pardon?
Okay. That is your application last email used
Yes.
by your clients.
Yes.
Where?
It is used by themselves. I have said that. And I have also said, my lord, that the process server.
You see, I don't know where I get the rule ordinarily was geared towards achieving a certain purpose, that is service. All right? That came about during the period we all know. And I take away the primary rule. Primary rule of physical service remains. Right?
Correct.
So, the import of that, the petitioner, the parties, not both parties, why how else would they be communicating and how else would the other? But and therefore you are just like the last known address when you are serving to the register. Address that you use last communicated between the parties. So in this case, that's why I'm asking the question. They have listed the email address, communicates between who and the who, so that I record that.
My lord,
Otherwise, if it is their last known address, just like that, I record it.
my lord, my answer to that question is that
Let me just get to them.
it's for them to say.
Which paragraph?
Paragraph 11, in both of the application, the averment as to the last
here is the first respondent.
And my lord, perhaps before I answer your question,
Let me record what you are saying. Yes.
my lord, my response to that question is the purpose of service is to personally make known to the other side that either the court has made an order or proceedings have begun. My response to that question, my lord, is that it is the obligation of the party who chooses to serve electronically to then persuade the court that, and that persuasion can only come in the affidavit of service, that the email address used is the defendant's or the respondent's last confirmed and used email address. That is the obligation of the party seeking to serve by email.
Text of the law.
Yes, that is the text of the law, and that obligation is not placed on the respondent in this instance, but it is placed on the petitioner who elects to serve by way of email. As your lordship has correctly pointed out, there are several modes of service. If my memory serves me right, there is substituted service where we can make an application to court and an advertisement is done, and there is email. There is so many ways to serve. Having elected to serve in this way, then it is the obligation of the petitioners to bring themselves within the four corners of the law, and I submit that they have not. My lord, I wish to state that the Inspector General of Police, the first respondent, is a different constitutional is established or is provided for the Inspector General of Police. Yes, yes, is established under separate constitutional articles from the National Police Service. I have seen under separate constitutional articles from the National Police Service. Yes. The National Police Service is established, yes, and the Inspector General is established. Yes. I have seen an attempt by the petitioners in the replying affidavit that I have perused quickly to state that the email address used was obtained from the National Police Service website. My lord, there is an absurdity in that position. One, the National Police Service is not a party to these proceedings. Secondly, my lord, the National Police Service is present almost everywhere in this country. If service on an officer of the National Police Service would then be deemed to be proper if that was the manner in which the email address was obtained, then untold havoc would be told. As was captured in the Sifuna decision, the email service is envisaged to be personal. And that mode of service or that mode of delivery or of sourcing of email addresses does not achieve personal service. My lord, the last ground I wish to argue in support of my application is the ground which I hope to persuade you to set aside the ex parte orders you made on the 8th of January this year. My Lord, the orders you made on the 8th of January this year require or are, for all intents and purposes, habeas corpus orders. My Lord, having issued those orders, the only conversation that remains before you is compliance with those orders. And my Lord, those orders were made. And I submit, my Lord, that you only made those orders at the invitation of the petitioners. Without the opportunity of hearing the responses of the first and second respondents. My Lord, with those orders in place, there is no terrain left in these proceedings for you to consider the substantive respondents of the first, second, or indeed any of the respondents. My instructions are, my Lord, that the first and second respondents do have responses to the application. And my Lord, my instructions are to very humbly request you.
Where are those instructions? I've not seen it here.
I beg your pardon, my Lord?
Where are they saying in the affidavit?
My Lord, they have said that they have been condemned and heard.
I'm not saying they have a response.
They are saying that they are entitled to respond.
I agree. But you see, you are telling me you have been instructed. So that is from the back.
I say they have a response, and what I am seeking is an opportunity to put that response on record. And it is for that reason, my Lord, that I beseech you to set aside.
So, I'm recording, I have instructions that the first and second respondents
Do have responses. And my Lord, prayer D in the notice of motion seeks leave for the first and second respondents to put in their responses. And my,
yeah. So you are saying you have instructions that they have a response.
that they have a response?
That's what I've
Yes, and my Lord, and to beseech you to set aside the ex parte orders you made, so that that response can then find its way to the record, and that your Lordship will thereafter have an opportunity to consider both the notice of motion by the petitioners and the responses by the respondents before issuing substantive orders in this matter. My Lord, needless to say that it is extremely prejudicial to my clients for ex parte orders of this magnitude to be issued against them. And like any other citizen in this republic, they are entitled to the right guaranteed by Article 50 to be heard prior to any orders being made. My Lordship, and my Lord, if unless you have anything you wish me to clarify, I urge you to allow the notice of motion by the first and second respondents, dated the 14th of this month, and filed in court on the 15th of this month. I'm most obliged. You guys go and support.
Question now, because it may be a assumed that I'm working for the petitioners. So the candidate has been the end. So I don't know whether anyone wants to say something from the respondent.
Lord, we can say something.
What is it?
And that is what I'm going to say, my Lord. On behalf of the third respondent,
The application I have is for setting aside the orders.
yes,
And the orders affect your client.
remotely, but not
What
directly.
is that remote?
He, my Lord, he is a respondent in this matter.
He is not the applicant. I agree.
Very well. Stand there.
Look at what is before us.
My Lord, the third respondent is the cabinet secretary for the minister and for interior.
I can see that.
Very well. And the IG,
But what is... I have an application as a first and second respondent.
my Lord, you could only allow me 1 minute only to associate
Before I
myself.
allow you,
Yes.
you need to know what you are going to tell us.
It is simply
That's
to,
relevant to the application before us.
it is simply, my Lord, that we associate ourselves.
How?
Because the cabinet secretary and the IG
No.
are intertwined.
No.
My Lord.
The confusion is here. He doesn't take he doesn't take direction.
On policy matters,
He takes instructions on policy matters.
yeah, the cabinet
And
can
not
issue.
command.
Not the command.
Yes. So the issue we have here is it on policy.
I can read the mood. I
It's not the
tactfully,
mood.
I tactfully retreat.
No. It's not about the mood. Because I must control what we are doing here.
Correct.
It's not for the mere fact that you are a respondent. You just come and say you want to argue. I
Much
have an
better.
application by two people who say the orders are against you. Is there an order against your client?
None.
So what are you going to tell us?
Correct.
I won't allow you to say something. You are number 3.
Yes, we are number 3.
Number 4.
My Lord, on behalf of the fourth respondent, we just pray that you give us a ruling to that application so that we can...
That's my word.
Most of
You don't need reminding.
Unless you have nothing to say, don't say, that's my word.
Yes, we have nothing to say, my Lord.
So, Mr. Omar, let me record you. You have something to say or nothing to say? And be frank. Because you know the nature of the matter we have.
I have nothing to say, my
It's
Lord.
not a job. You're not doing anything for the sake of it. I have an application to set aside.
I have nothing to say this time.
Thank you. So your team has very many people. So who do I record?
My Lord, you can record me on behalf of the fourth respondent,
Mr.
Barasa M.
Yes.
Yes, my Lord, on our part, we will not be making any presentations on that application.
Mr. Kuria.
Yes, my Lord, on behalf of the fifth respondent, I pray that you grant me 2 minutes to support the application by Mr. Nyamodi. And in doing so, I'll be laying more emphasis on the issues that have been raised at paragraph 12 and 18 of the supporting affidavit of that application. And I have an authority, my Lord, which I'd like to submit to court and just make brief submissions in support of that application.
You supported the application.
Yes.
That's all you can say.
No, my Lord, I needed like 2 minutes to just issues of law, which I may need to clarify on behalf. And I'm saying this because I think regarding the question that you're asking my learned colleague, Mr. Dunstan, I believe the issues that I'll be raising, issues to do with the right to be heard, miscarriage of justice, and the public interest are within the domain of the Attorney General under Article 156.6. And if you allow me just 2 minutes, I'll be able to.
So are you supporting or opposing the application?
I am supporting. And I have an authority, my Lord. Yes, my Lord. Thank you so much. My Lord, on behalf of the fifth respondent, I support the application by the first and second
That's the only
respondent.
application we have.
Yes, my Lord.
Let's say you support the application.
Yes, my Lord, I do support that application.
Yes.
And in submit on the issues that have been raised at paragraph 12 and paragraph 18, and I will rely
There are so many things which are paragraph 12. Forgive me for that.
yes, my Lord, and I think those paragraphs limit themselves to amendment made on the grounds that have been raised
So in paragraph 12,
the supporting affidavit by my Lord, in those,
you support the amendment,
yes,
position,
that have been raised at paragraph 12, paragraph 12 of the supporting affidavit to the application on the grounds that the orders of this court issued on the 8th of January 2025 ought to be set aside.
No evidence that we have obtained.
Yes. And subsequently on the 13th, my Lord. We will not do that. Yes. And my Lord, in doing so, I have submitted before you an authority of the High Court in which other decisions of the Superior Court and the Court of Appeal in particular are quoted on an application to set aside the duty of the court when it's presented with an application to set aside and the premises upon which the court discretion. At paragraph 12, my Lord. Yes, my Lord. At paragraph 12 of the supporting affidavit to that application.
paragraph 1 of the decision.
No, I have, yes, oh, sorry, my Lord. I'll be strictly confining myself to, I have highlighted paragraph 49 and 52 all the way to 54, where there's an exposition on what the court is supposed to do in an application to set aside ex parte orders. How the court is supposed to exercise that discretion, my Lord. Paragraph 49 is on grounds of public interest. And then on the right to do justice to all the parties to the suit.
So you go on paragraph 49.
Paragraph 49, and then paragraph 52
Not 51.
Sorry, 51 to 54. 51 to 54 of the decision by Justice, your brother Justice. It is persuasive, but at the penultimate paragraph, my lord, you will find the decision of the Court of Appeal in Mwenesi versus Shari Lancaster and another civil application number 170. A court of law has no jurisdiction to do injustice. That is a decision of the Court of Appeal that is binding, but the other issues are issues that I would like to persuade the court in making that determination. My lord, if you look at prayer number 1 of this application, the applicants are beseeching this court to set aside the court orders that were issued on the 8th of January and the 13th, and at paragraph 13, they have read the basis as the right to be heard, in the sense that these orders were issued by the court right-free, exercising its discretion in matters brought under Article 22. But my lord, on behalf of the 5th respondent, and the reason, and I want to say this, my lord, because prayer number 1, or even when the court exercises discretion, when, for example, you stay your orders, we are not doing away with the orders that we issued. We are just simply coming before you and saying, stay your orders so that, and if you look, my lord, what is presented before you, and the applicants have come before you under Article 51, Sub-Article 2, on the right of habeas corpus. Habeas corpus, my lord, and I want to submit strongly that under Article 25 is one of the non-derogable rights. Equally, the right to be heard is non-derogable, and therefore we are at an equal pedestal when we are exercising our rights, or rather the applicants are beseeching you to exercise your discretion, set aside the orders, or stay at the very best your orders, grant us that limited time to be heard as provided under Article 50. And then, during the inter partes hearing, this court will make an informed decision on how to sustain those orders, or even to vary them, so that each party is put at an equal footing. And these orders, my lord, are discretionary, are in the interest of justice. I have said, my lord, equally, the respondent will feel, and I support what Mr. Nyamodi says. For example, if you look at Article 22, and of course the court has sat in several matters of this nature, orders of habeas corpus under Article 51, Sub-Article 2, are orders granted where the applicant is in custody, lawful or not in a lawful custody, such that he is produced in court. If, for example, my lord does not exercise that discretion to just stay those orders and hear the parties on the allegations that have been made before them, then ultimately the parties will be condemned unheard. And what the respondents are just craving for is setting aside and listening to us, inter partes, so that you make an informed decision. Because habeas corpus, by very nature and how they are crafted, they are final orders, and there can never be a fishing expedition to just look for evidence on the assumption that the respondents are holding. And I think I will rest my case at that point, my lord, and ask you to...
So you've been... Now that forces me to intervene, ask a question.
Yes, my lord.
I've been restraining myself, and now it's like I have to ask you a question. The applicants or the petitioners come before the court and say what they say. Right? Now, you are here urging us to set aside the court orders. We will consider that.
Yes, my lord.
And you must have heard me ask Mr. Modi, I'm not doing their case, but now I have to ask you. When you say you want an had. And I've read the affidavit. This applicant's case, because cases for setting aside the orders. All right? What have they said is their defense? When you look at their, you must have seen their applications, you must have seen their applications. And you have to report Mr. Mlolongo verbatim as instructions that they have a defense. So
I listen
those
to-
are the things that
yes.
I was avoiding to go into. And in here, as you rightly said, habeas corpus by its nature. Yes? It's a very serious matter.
Yes, my lord, I agree with you.
It's a very serious matter
Yes.
that we cannot just look at and say all this or that. So the issue you are saying, I hear, but I'll make myself, I don't want to say much.
I get the concerns of the court.
Let me leave it again.
Yes, most obliged.
So you are,
My lord.
the respondent, the petitioner, this one.
Yes, my lord. For the petitioners, we are asking for just 15 minutes.
I give you 10. I give you 10. I know it. Only 10. Give you 24. So,
I'm very grateful for this service.
so I'm giving you 10 officially, but I'll allow them on the situation.
Okay, my lord. But
So
firstly,
you oppose the application?
yes, my lord, we oppose the application. We have since filed and we rely on our replying affidavits sworn on the 16th, which has also been served on all the respondents.
Give me a minute.
Okay, my lord.
It's allowed, were your plans allowed in?
Yes, ma'am.
Yes, ma'am.
I really want to thank you. Thank you, my lord.
So, Mr. Proceed.
Yes, my lord. So I will address the last limb of our submission. One.
So organize your thoughts.
Okay.
This is not the kind of case where you split. You argue a point, the other one argues a point.
Can we do two here, my lord?
Why? I don't allow. 10 minutes.
Yes, my lord.
By the time you change positions,
No, my lord.
3 minutes have gone.
Yes, I will only take 3.
Let's put your thoughts together.
Yes.
These are small matter.
Okay. Okay, my lord.
I'm giving you a minute to organize your thoughts.
Thank you, my lord.
Short.
That's fine. That's fine. Okay. That's fine. That's what I did. Okay, yeah, that's fine. That's fine, my lord. And I'll go. Sure, my lord. I will start on the first ground on the powers of this court to grant interim reliefs. It has been claimed that they are final in nature and that they occasioned miscarriage of justice. My lord, Article 23 of the Constitution grants this court the authority to issue an appropriate relief including interim reliefs. Yes, my lord. This court and also the apex court, that's the Supreme Court of Kenya, has interpreted that provision in Gatirau Peter Munya versus Dixon Mwenda of 2014, application number 5 of 2014 at paragraph 86, that interim reliefs are issued so as to enforce the Constitution and they are public in nature.
So which paragraph?
86. They are public in nature and are issued to enforce the Constitution and also for the protection of human rights. My lord, Rule 23 of the to ex parte interim reliefs. 23. So the question is, what was the appropriate relief as at that time when the application and petition were filed? In that application and petition, the first petitioner alleges that the second to fourth petitioners are missing, and therefore asks for a habeas corpus order requiring them to be produced. And this court, it was kind enough and ordered that they be released and or in the alternative, the first respondent and the second respondent to appear in court. Therefore, the question of the right to a fair hearing cannot arise when you have been given a chance to appear and you fail to do so. On that point, my Lord, I will rely on the decision of the ELC courts Andrew Ndaba Karanja, ELC E201 of 2022 at paragraph 66. It is Andrew Ndaba Karanja versus Ambassador Simon Nabukwesi. It is ELC number E201 of 2022.
So I'm saying it is unreported.
Yes, it's a recent decision.
Sure, my Lord.
It was delivered yesterday.
Yes.
Yes, it was delivered yesterday.
You are not in that.
Yes, my Lord. Now, on the second issue of public interest,
So which paragraph are you remembering?
at paragraph 66 of the decision. 66.
I hope you have freedom your colleagues.
I've been gifted with a tablet. I hope I can keep it.
That's not on my folder.
Yes, my Lord. Then, at the other point, is that the public interest lies in lifting the orders as it was advanced by my senior, Mr. Kuria. We submit that that is not the case. Public interest lies in the strict observance of the Constitution. Article 238 lays down the principles of national security, which includes the respect of the Constitution and its values. When the right to life is threatened, Article 238 of the Constitution lays down the principles of national security, and this includes the respect of the Constitution and the values and principles. The respect of the Constitution, the rule of law, and the national values and principles. My Lord.
Let me put respect to Article 10.
Sure, my Lord. Sure, my Lord. Yes.
Is that the way to put it?
Yes, my Lord.
Repeating those things.
Yes. Yes, we can summarize it as the
Response in Article 10.
10. Yes. So, my lord, when the right to life is threatened, public interest lies in holding the security agencies accountable. One of such ways is giving them a chance to come and explain. Your order issued on the 8th does that, my lord. My lord, now I'll go to the second issue on service, where much time has been spent on it. Firstly, my lord, when you retire, you will note that all those authorities submitted to you are distinguishable.
So, what is your point?
On.
See, you should tell me the point, then you go now to explain.
Oh, okay, my lord.
What is the point regarding service?
Regarding service, and second, respondents were properly served. From our replying affidavits, my lord.
You can now go to those decisions.
Okay, my lord. Okay. So the point that I was advancing is that the authorities submitted before you, they are distinguishable and inapplicable in this scenario. We say so, my lord, because the authorities submitted, they don't touch on service on public officers or public officials or public offices. They are all personal disputes in civil and commercial. The case here before you is about public officers on whose contacts are publicly available. Yes, my lord. And if you refer to our paragraph 10 of our replying affidavit, the CEO of the first petitioner, Florence Muturi, advised that the Law Society of Kenya has previously served these offices through the same emails. And she refers to the ongoing case has previously served court documents to the same respondents using the same email addresses. That is paragraph 10, subparagraph B. And she lists down the case number. Paragraph 10, she refers to the last known addresses of these public officers. And she avers that when the first petitioner filed High Court petition number E714, of 2024,
714.
yes, of 2024 24, it served the court documents using the same email addresses. And when the society appeared before your brother, Justice Mamuye, no objection was raised. And my lord, the very same counsel was on record and was in court that day. Senior counsel Nyamodi. He was representing the very same parties. And then time was also spent on the contents of an affidavit of service. My lord, when you retire, you will consider Rule 14.2 Form B of the Mutunga Rules. It provides for the contents of an affidavit of service. Form B issued under Rule 14, Sub-Rule 2.
So, Mutunga Rules 14C.
Yes. Form B.
Sub-Rule 14.2.
Yes, my lord.
Form B.
Form B.
Capital B.
Yes, my lord.
Yes.
Yeah. A person serving is only required to address how it was served with no extra requirements of extracts. We submit, my lord, that at Mutunga rules regulate petitions, and the civil rules can only apply, if at all, where there is a gap. We submit that there is no such gap. And lastly, my lord,
I was just about to ask.
Yes, my lord.
Lastly,
There is no evidence before you that those email addresses do not belong to those public offices. Article 245 of the Constitution establishes the office of the IG of Police and in the National Police Service, and he is the commander. He is the one responsible.
that is the first respondent.
Respondent. Yes, my lord. So, if that office is served, my lord, then such a high-ranking officer can be accessed through that email. How else can Kenya ranking officer in order to effect service? I will end, my lord, by referring to a decision that I am the youngest here on the bar. That the prayer to set aside is a discretionary relief. It must be demonstrated that there is hardship.
There are two positions.
Yes, my lord.
The
Shavas Mbogo, and another of 1967, East Africa. At page 116, my lord. 116. Yes, my lord. So, yeah. So the prayer to set aside is a discretionary relief, and it can only be granted where there is extreme hardship or a miscarriage of justice, my lord. But they cannot be delivered or granted where they are being sought to obstruct the delivery of justice. Kenyans, my lord, and the families of the second to fourth petitioners want to know where their siblings are. That is the main goal of this application and petition. Setting aside those orders will not lead to that result, my lord. It will actually allow the bleeding of the Constitution. And as Senior Thande Kuria submitted the jurisdiction to do injustice, we submit that the High Court of Kenya, established under Article 165, does not have the jurisdiction to allow for the violation of the Constitution. That will be all from us, my lord. Thank you for the opportunity.
So what is your prayer?
My prayer, my lord, is that the application be dismissed, my lord,
I'll wait for you when I get
and the orders granted and 13 be confirmed.
I'll take it from you when I'm ready.
Mr. Nyamobi, I'll give you 3 minutes.
My lord, just to start quickly from the bottom, the decision of Shah versus Mbogo needs to be read together with the celebrated decision of Express Kenya versus Manju Patel. And in that decision by the Court of Appeal at the apex court of this country at the time,
Shah versus Mbogo.
read together with Express Kenya versus Manju Patel,
Read and understood.
read and understood together with Express Kenya.
With
Express Kenya versus Manju Patel,
Manu or Manju?
Manju, M-A-N-J-U,
Yes.
where it was held that where it is,
Citation.
I beg your pardon?
Give me citation.
I don't have the citation. I know the decision because I have relied on it before, but I didn't know I was going to use it because I had it 2 minutes ago.
So you're asking me to go and look for the citation?
I can supply it to your court clerk.
No, it's okay. I'll get it.
Where it is held, my lord, that where it is established that service was not effected.
So that where
It is established that service was not effected.
that service
Then the orders made by the court should be set aside ex debito justitia as a matter of right, as a debt to justice.
started should be set aside.
Yes, ex debito justitia.
That's what Omondi said. Is it Omondi? The other one he said Patrick.
Yes, that is what it says. My lord, the reference to Rule 14 of the Mutunga Rules
As a matter of right.
as a matter of right. My lord, the reference to Rule 14 by Learned Counsel for the petitioners is an afterthought. The evidence of service, and I will come.
Rule
of the Mutunga rules is an afterthought, because the evidence of service is the affidavit of service of Noel Oduori of the sworn on the 13th of this month. And in that affidavit of service, the law or the procedure directing service, according to the deponent, is Order 5, Rule 22, B and C.
Order 5.
Rule 22, B and C. And this, my Lord, there is the submission about, or the question that Learned Counsel posed to court. How else are Kenyans expected to reach certain high offices? Inferior quality of service that the petitioners have answered. It cannot be then Article 50, and it is for the petitioners then to ensure that the quality of service that they effect complies with Article 50. Everybody is entitled to the protection under Article 50, and I had stated in my submissions in chief that service is the gateway to Article 50. If this quality of service is allowed, what will happen next is that Learned Counsel will wait for the Inspector General's car to drive by, and he will fling pleadings at it and come to court and ask, but how else did you expect me to get to the Inspector General? My Lord, the responsibility to effect service is on the officer authorized by the court to effect service. That responsibility is not co-shared between the officer serving. If he is not an advocate, the advocate instructing that process server, or the client that is instructing the advocate in the matter. That responsibility is on the person who served process. I say so, my Lord, because there are explanations in the replying affidavit to the application that is before you this afternoon that seek to make clarifications about the affidavit of service. When your Lordship considered this matter on the 13th, what was before you was the affidavit of service. That is what evidences service, nothing else. My Lord, paragraphs 12, 14, 15, 16 of the replying affidavit are not contained in the affidavit of service. And because I have submitted that that responsibility is not co-shared, it is important for me to submit that those are not averments by the process server. Whoever is deponing to this affidavit merely instructed the process server to serve. They did not effect service.
Mr. Yamodi, you are on one hand, you notice I'm looking for something, so you don't expect me to record you.
Most of them.
I'm looking for the affidavit of service.
I had asked earlier. My Lord, let me tell you where the affidavit of service is. My Lord, it is on page 29 of the notice of motion. My Lord, that is the proof of service. And really nothing else can be the proof of service. Any explanations rendered after the fact are after the fact attempts to improve the poor quality of service that is not in compliance with the law. My Lord, there was a very innovative submission by my learned colleague that the authorities that were cited are distinguishable because they do not relate to service on public officers or holders of constitutional offices. Again, I repeat what I have said, and I think I'm saying it now for the third time. Service is the gateway to Article 50. And for that innovative submission to hold water, then Learned Counsel was obliged to put before your lordship that constitutional office or holders or high office holders are then not entitled to the protection under Article 50. Because what he is suggesting is an inferior quality of service. There was the submission that email contacts that were used to allege